no,
We did it.
I'm actually not.
Nothing you do is legal.
Or at least some.
Aren't you just like-
It's just compliance. Never seen you around. You can't just say so. Try about that. But I wouldn't make it.
There's like the whole thing behind it. Yeah.
Oh, yeah. Actually, I got
They want that phone, they'd be like, hey, can we do this?
Yeah.
Can we do this? Hey, you never know.
Yeah, I could be.
We can be what?
I could be.
I know, you know, I'm saying, like, in the beginning.
Look.
we all got to stand, like, yeah. Yeah.
Good afternoon.
Good afternoon. Mhm.
So, we've got some administrative things to do, but I want to start as we always do with our practice questions. So we'll do these, and then we'll talk about administrative stuff. And then we'll get into today's material. So here we have a situation involving a representation where the attorney is unable to determine whether the disclosure in question is authorized, and he calls up another lawyer to get advice. And unfortunately, the nature of the representation is such that even if he uses a hypothetical, as we recall from comment 4 of Rule 1.6, it's obvious what he's talking about. And so along the way, he makes this extra disclosure not related to the representation, rather related to personal choices. And so the question is, are we subject to discipline in this circumstance? And Socrative is open, and here are your answer choices. Give you guys a minute. Give it a few more seconds to roll in. Okay, so we'll see what else, see if anything else comes in. But for you guys, so most of you, in fact, I would say all but one of you, are convinced that this guy's in some deep doo-doo. The question is why, right? Because some of you think that the issue is he said too much, and some of you think that the issue is that the hypothetical didn't protect the client's identity, okay? And the answer is B, right? Said too much. The personal choices of the client, not required to answer the question about what disclosures are permitted, because think back, right? The disclosure in question is information is already a matter of public record. Well, this not in fact a matter of public record. At least I hope not, since it says that each of the client's paramours are not aware of the existence of the other. So it would be a neat trick to have that be a matter of public record and not have these two folks find out about it. So what you're asking for advice on is separate from this extra disclosure about the client's secrets. Okay, so you probably, the hypothetical issue is a red herring fact, because it wants you to think about the comment for issue, but this isn't a comment for question. This is a 1.6b4 question. And this is advice required to obtain, this is disclosures required to obtain advice on compliance with rules of professional conduct. Okay. So C, for the one person who said it, right? You correctly captured the issue. So you didn't run afoul on the comment for rocks, but you missed the fact that the disclosure isn't connected to the issue for which advice is sought. And then, of course, as per usual, we're back, D, we're back in the world of the rules don't care about outcomes, the rules don't care about your promises, the rules care about your actions. Okay? Questions? Okay. Next, we have a poaching question, hopefully one that will become very relevant for you guys in a few years as firms compete for your genius and savvy, and also your books of business. So we're not running afoul of any attorney-client privilege issues. This is just a Rule 1.6 question. That's why we sort of have this mention of a transactional lawyer. And the new firm obtains the lawyer's client list from him, right? All the clients that he represented at the old firm. It's used only for a conflict check. They don't try and steal business except for the clients that choose to come with the lawyer into the new firm. And no client was asked for permission to disclose this, this information. Is it proper or not? Give me just a second. Yes. All right, so the Socrative is ready for you. And here are your answer choices. All right, give this a couple more seconds. Okay, so you guys do not have a strong sense of agreement here. More or less an even split between B and C, right? Some of you thinking that this is fine because it's specifically about a conflicts check. Some of you thinking it's not okay because there was no consent obtained. And then a significant minority of you are concerned that other lawyers' clients were disclosed. So the answer is B. So this is a specific exception to the 1.6a bar on disclosure. 1.6b7 allows the disclosure of facts related to the representation specifically for a conflicts check related to new employment. Okay. So if you said C, you correctly applied 1.6a, right? Disclosure is barred unless the client gives informed consent. But 1.6b creates a whole list of exceptions to that bar. These are conditions under which attorneys may disclose information, and 1.6b7 is specifically applicable. I appear not to have explained why D is incorrect, and I'm not going to try and do it, on my feet here. But A is incorrect because you can't, assuming that there was a breach of the rules by not obtaining the client's consent for the disclosure, you don't get to fix it by going back and getting the client's consent after. Like, that is not how linear time works. So questions. If your question is why is D wrong, I'm not answering it. Go ahead, Mr. Thompson.
No, I put C because it didn't seem like he needed to give information about the issues of those clients, but just provide the client list. So I knew about the rule 1.6.7, but it seemed like he violated that by, like the previous question, where you didn't need the information about the personal life.
So here's the issue, right? If, let's suppose, for the sake of argument, that I represented let's suppose that I represented Dean Jackson in a divorce. God willing, that never happens. A, I hope he never divorces his wife because she's amazing. And B, if he does divorce her, I hope he does not come anywhere near me for seeking help because I was a terrible divorce attorney. But let's assume for the sake of the hypo that I represent Dean Jackson in his divorce. And then a couple of years after that divorce is complete, I move to a new firm that is representing a company that Dean Jackson is suing in a products liability case. Absolutely, if the only thing I tell them is that I have represented Dean Jackson, they can't offer me the job because I'm conflicted, because I represented someone whom they are adverse to. But the conflict rule is not that stark. The conflict rule does not allow you to represent someone if you represented the adverse party in a related proceeding. And so that's why new firm needs information on what the client's representations involved, because they have to be able to know whether the conflict is sufficiently, whether any prior representation was sufficiently related that there's a conflicts issue.
It still seems like he gave too much information,
Mhm.
because if you send the client list, prospective employer looks over that list, sees 4 people that they have as clients, then they sit back and say, how did you represent them? But if he's giving information on every client that he's handled, and 98%, they don't need to know that information, that's still okay?
I think what I would say is this is an issue, this is a difference between what the rules allow versus what best practices would suggest, right? I think that probably you're right that that as a best practice, we should let this be an iterative process, right? But that might not be what happens. And the last thing that you want to do is put yourself in a position where you could lose this job offer, right?
They are on the side of caution.
Right. So if the new firm, if you don't provide enough information, the new firm has to assume that there's a conflict. And then they can choose to come back and say, okay, give us more information about these particular clients that might be conflicted, but they might not. And so since the rules don't require you to under disclose, that's sort of the situation, right? So does that help?
Go for the job.
Exactly. So, all right, other questions? Okay. So we have our legal aid clinic, which is a mandatory reporter under the relevant state law. And we have a prospective client who does not qualify for representation. Doesn't say why, but probably it's because she makes too much. And pretty clear evidence of child abuse from the child, sort of physical evidence. Mother's unreachable, is reporting required. So here are your answer choices, and give me 1 second. And take it away. Give this a couple more seconds. Okay. So most of you say, yes, this is fine. Disclosure is required under state law. There's an exception under 1.6b. A significant minority of you argue that 1.6b is permissive. And so there's discretion for the attorney in disclosing or not. So let's see what the right answer is. So A was correct. So you correctly applied that the 1.6b6 exception. You have a state law that's generated this obligation to report, right? In order to comply with the state law, the disclosure must be made. Okay. B is incorrect because prospective clients are entitled to the same 1.6 protection as actual clients. So for those of you who said C, let's talk for just a second. Okay. It is not unreasonable to read the rules in this way. In the sense that when we talk about statutory interpretation, right, we talk about shalls and mays and how may creates this discretion to act. But you have misapplied that statutory interpretation beyond the scope of the rule in question. In the sense that the discretion to disclose does not affect the obligation to disclose under state law. Okay, so 1.6b creates situations where disclosure does not subject the attorney to discipline. Isn't. But that freedom from discipline does not affect whether the reporting is obligatory or not. Okay, so think about it like this. If 1.6b6 did not exist, then the attorney in this problem would still have an obligation to report the child abuse under state law, but they would also be subject to discipline for doing so. And so, like, they would have to choose which law they were going to break. The purpose of 1.6b6 is to save them from that sort of Hobson's choice. Okay. And that's the only work that it does. All right. Okay. Nobody answered D, but I just want to point out for D that 1.6b6 does depend on the substance of the state law of the law requiring disclosure. Okay. And D correctly captures that, but it misstates the relevant state law. Okay. All right. So questions? Yes.
So it's, the reason C is wrong is kind of because where state law creates a must and the rules create a may.
The must wins.
Yeah, right. And
Yep.
so the may kind of turns into a must.
Yep.
Where state law requires.
Yep. So all that C is doing is it is assuming that the rules of professional conduct are the only rules that lawyers have to abide by. That we know that that's not the case, right? Okay. Other questions? Okay. Then let's take a break from this. We're going to come back to this in a minute. I have one more slide to talk with you guys about, but we're not there yet. So let me. Okay. So the whole idea behind today's discussion is that we want to talk about the ways in which the 1.6 duty sort of fades away. So we start with the 1.6a exception, which of course is client consent or implied authorization. So let me start with this. Oh, but I promised that we talk about administrative things, and that those are important. So let's do that. First of all, you guys need to remember, and this is not directed at those of you who've already taken care of this. Your character and fitness application is due on Friday, and because I know for a fact that and I know this because some of you have already started emailing me. Law students are endlessly inventive at coming up with reasons for why they shouldn't have to do work. So let me just say, I don't care where you're taking the bar. I don't care what your bar application's character and fitness looks like. I don't care if you're skipping the bar exam. I don't care if you're going to run screaming into the night and never come anywhere near the practice of law in your whole entire life. You are doing a character and fitness application. And that here endeth the inquiry. The other thing that I want to draw your attention to is that the sample application on the NCBE website is not user friendly because they don't they don't actually. So if you're doing an NCBE application for real, it's an online portal. The paper form, the PDF form, is just for illustrative purposes. And so the best advice I have for you is that there are solutions out there, and I'm not the person to ask tech support questions of. So I would encourage you to exercise judgment, to exercise adaptability, and there's any number of possible solutions. Folks have printed off the form, handwritten their responses, and scanned them in. That's perfectly acceptable. If, like me, your handwriting is completely illegible, then there are various software solutions that are available to you, either to edit PDFs or to import the PDF into a Word document so that you can edit it there. Beyond that, I don't have any solutions for you. The one I poked around looking for an editable version of this form for you, or something that could be converted into an editable version of this form, and found myself on a very cleverly disguised phishing link. So had to email IT and be like, guys, I might have compromised my office computer. So see what happens with that. But I'm sorry.
Sorry, I had a question.
Yeah, I think that's the end of my sentence. So go ahead.
So if your answers are just really check no and leave the rest of the box, right?
Whatever the form tells you to do. So I'm afraid I don't have any more guidance for you than that, because I can't speak to specifics. Yes.
Kind of along that same line, I think it said in the assignment sheet that if we were checking a box yes or no, that we needed to briefly describe it on those few that I think you're talking about the same one. That it says have you ever applied to take the bar exam, including the UBE? Do we have to briefly explain that? No, I have never applied to take
Just
the bar
that
exam.
military service and a couple other things too.
I mean, I think the form sort of has to speak for itself. So if it asks you to explain your answer, you should follow the assigning memo in explaining your answer, because the explanations are where the character and fitness asks for all your dirty laundry, and I don't want it. But if you would not have to explain your answer, whatever that answer is, just
Okay,
keep going.
that makes sense.
Yeah, yes.
I'll just make a quick comment to the class and do a lot of trial and error on Sunday. And Stacy and I texted a lot about our frustrations. What I ended up doing was subscribing to Adobe for their free 7-day trial. Edited the document that way instead of trying to convert it to Word because nothing lines up.
And
And it took hours. It was pretty frustrating. So anyway, I finally got it done and submitted, and now just don't forget to cancel your free trial. So,
I did call Campus IT to see if the university provides a Creative Cloud license for students, and they do not. So such is life. My apologies on that. So yes.
I apologize if you already answered this, but do you want us to attach documents like it's like a DD 214?
No, I don't want to know your business. So the bar does, and I definitely want you guys, like, part of the purpose of the exercise is for you to go through and acquire the things that you will need when you do a character and fitness application. But like, I don't want to see all that. I don't need to know. Like, I don't need to know that you did a 1.5 years in prison for coke when you were 19. Yes.
You care mostly that we have where we lived for 10 years and the employment together. Is that
I care that you complete the form. So look. If you guys want to sit here and fill out the NCBE form and have your addresses listed as Wonderland and Oz, I'm not going to tell you you're wrong. I am going to tell you you've wasted a bunch of effort. So like, I don't, I want you to take this seriously, but I'm not going to be fact checking you.
I think you even said in the instructions, you can make up every bit of it, just fill it out.
Exactly. So, okay. Any other question? Oh, the last thing I'll say about the character and fitness thing, sort of, that I want to say is, like, and it pains me to do this because this is not the kind of instructor that I am, but like, the deadline on Friday is the deadline. It is the drop dead deadline. Because when you fill out your bar application, if you go to the bar examiners and you say, oh, I got sick this week and I didn't finish my character and fitness application, can I submit it a week late? They'll say, sure, we'll see you at the next administration. Okay. Like, I understand that life happens and I want to be sympathetic, but if this happens to you, and God forbid it will happen to none of you, but if this happens to you, this is a very important, low stakes opportunity for you to learn the value of planning ahead. In that you have known that this assignment was coming since you walked in the door on January 17th. You could have taken the opportunity to do it a little bit along and not run into a situation where if you get sick at the last minute, you're going to miss the deadline. And by not doing that, assuming that you did not do that and assuming that you missed the deadline, well, there are consequences to that. If you do it with your real bar application, the consequence is you're going to wait 6 months to start your career, at least. If you do it to me, the consequence is, well, now the best you can do in this class is like probably a B. So, and I'm sorry for that, but like, this is the point of this, is to encourage you to take that away from this. And so that's kind of where we are. Yes, Ms. Gleason.
This is kind of general. When we really do this for the bar application, it's due at the time that you submit your bar application, right? Those deadlines are the ones.
Every jurisdiction is different.
Okay,
I think that most jurisdictions, certainly the jurisdictions that like Washburn students tend to take the bar in, do character and fitness before the exam. So you submit character and fitness with your bar application, and they do whatever investigation they're going to do. And if they call you down for a hearing, they call you in for a hearing, and then you take the exam. But I know for a fact that New York actually does character and fitness after the bar exam. And so I'm not sure when you submit your application there, but you go to the Javits Center, you spend 3 days dealing with whatever nonsense they hand you at that administration, because something always goes wrong at the Javits Center. You get your score, and then they may tell you, in fact, you are not admitted to practice. So that's kind of where, so the answer to that is, you will be advised of what the deadline for your character and fitness application is. Most likely it will be with your bar application, but it might not be. Okay. Any other questions? Okay. So, the other administrative thing that we need to talk about is we are now a day behind on the syllabus. And I thank all of you who reached out to check in on me, and all of you who, thought your well wishes, even if you didn't express them. And those of you who said, I hope he breaks his leg. Well, God watches. So, all right. So the issue is, how do we make sure that we cover the things that we need to cover without sort of finding ourselves in a situation where we are really rushed, especially towards the end of the semester or towards the MPRE at the end of next month. So there's a few options, right? One is we do have a built-in canceled class in this class where I have demanded of you a Saturday, and I have given back a class day in exchange. I could set that, the session that I've given back as being last Thursday, and so we meet on the day that this class is canceled. It's the Thursday before spring break. Another option is we choose a topic from the syllabus that we are going to have be self-directed. So you guys are still going to be responsible for that material, but we're not going to have a live class discussion on it. You're going to do the reading, and if you have questions, you're going to come and talk to me, but there's not going to be sort of this kind of space. A third option is kind of similar to the second, in that I offer you some sort of asynchronous learning exercise where you demonstrate that you've engaged with the material, and that's what we do for that particular topic. And I'm also open to creative solutions. So these are the things that I've come up with, but that doesn't mean that there aren't other options. One thing that is not on the table is cutting something from the syllabus. If that's what we have to do, then that's what we have to do. But that is, so we're not going there. if that's where I decide to go, I don't need any student input on that. So what do you guys think? Yes,
I wouldn't mind the asynchronous one. I think the direction to these topics is pretty good.
okay. Anybody else?
I like option 2.
I vote to.
Okay, so just sort of a self-directed, yeah,
Just to be super clear what that is so that I can really focus.
well, I mean, you would be told, like, we are skipping this reading, you are responsible for this reading on your own. I will not just sort of like leave you to twist in the wind on this. Other thoughts? Why do you like option number 2?
Why?
Why?
Self-teach. You assign it, we read it, we learn it. We don't have to come to an extra class or a makeup class.
Why do you like the async option?
I don't know, I just feel like with a lot of these issues, there's kind of a lot of sticky spots and having a little extra affirmative teaching about why the stickiness exists and how to navigate it is pretty helpful. But I think the other option would also be fine.
Okay,
Because like you said, we could still come and ask you questions if there's a true issue.
well, one of the things that concerns me about the self-teaching option is the fact that, you know, sometimes, and I can't point to any specific instances that this has happened, but sometimes students don't even know what they don't know. And so you review a material, you self-teach, you feel confident, and then it turns out there was something that you missed. Or if you're taking my morning class, something that you weren't told. So, all right. Last chance to weigh in on this. Yes.
What if it's a hybrid? What if it's a self-directed topic from the syllabus that you tell us about? But then there's a quiz or like a.
Yeah, like give
soccer
4
tip,
questions.
And
Then
then,
we answer, turn it to you with the applicable rules.
yeah. Like the quiz.
I mean, that's more or less what I'm talking about when I talk about an asynchronous
Okay.
option. So that I okay. Well, you'll hear from me in the next few days about what we're going to do with this in terms of like how we're going to do this and also what topic we're going to do it with, so that you guys know when things need to move forward. Okay. Yes.
Okay, I have a question, sorry. I'm looking at the syllabus now. So for the March 4th practice MPRE, is there another day that we can take the practice MPRE, or is that the only day, that Saturday?
The answer is I'm not going to be like a hard ass in the same way for that as I am with the character and fitness application. But like, you got to come and talk to me and explain to me why not you specifically, but whoever you are, why you get to have a Saturday and nobody else does. So, you know, I'm not sort of suggesting that any particular story would satisfy me one way or the other, but like, if you're getting married, probably I'm going to say, okay, we can figure out a different day for you. You know,
Do you know what time?
I gotta get with the administrative folks and book the room and whatnot. So
Okay,
my instinct is to target it, you know, late morning, early afternoon. But it'll just depend on sort of what they can offer me.
okay.
So, okay. No, it's a fair question, and I don't mind, you asking it. But like, if you want to get an alternate date for yourself, you're gonna need a pretty good reason for why you're special. So, all right. Other questions? Yes.
Just checking on that practice, are we coming here to?
So it'll be here in the building. Again, because I haven't set up the room reservation yet, might not be in this room. Certainly that's going to be my target, but if somebody else has already sniped this room for a Saturday afternoon in early March, then we'll be in a different room, but you'll be told where to go and when to go. So, okay. Other questions? Okay, so now let's have an abbreviated lesson on 1.6b 6. I'm sorry, 1.6b. And also the exceptions in 1.6a. So let's start by asking, how informed does the client consent have to be for client consent to excuse a disclosure? Well, let's start with an obvious one, right? Obviously, consent must precede disclosure because we live in a linear time world. We do not live in a wibbly wobbly, timey wimey ball. But what does the client have to know in order to consent?
So it's full disclosure, which to me means that you need to tell them what you're disclosing, why you're disclosing, and the possible implications of the disclosure.
That seems like a lot to me. Does it seem like a lot to you guys, or does it seem right?
Well, it's their information, they're the ones who have, they should have all the knowledge to make sure you're not disclosing your personal information for a good reason.
I mean, certainly we want to be careful about disclosing, the fact that we're having two affairs, neither of which know about the other, right? I mean, what do you guys think? Does that seem, do you feel like Mr. Reeves is right? Or do you feel like he maybe is being a little too cautious? Don't everybody jump in at once. Yeah, that's right.
I agree. I think that's right. I wouldn't want someone to go, say, talk about my business. I would want them to really check with me beforehand. So I feel like I should owe that same respect to my client as well.
How much of that information should be disclosed in writing? So, we have a couple of decisions that the book mentions that sort of push in the direction of written informed consent. So, the client has to sign a piece of paper that says I consent to the disclosure. But, how much, assuming that Mr. Reeves and Ms. Harding are correct about what goes into an informed consent, how much of that needs to be reflected in the thing the client signs? Yeah.
Probably as much as reasonably necessary, and the book just says it'd be prudent to obtain the consent in writing. It's reasonably necessary.
I think that's probably right. So, as per usual, anything that a client signs should probably, recite everything that was done for them, even if the details of what was said and done aren't laid out. So, as Mr. Reeves points out, I was advised as to what would be disclosed and the purposes of said disclosure and the implications of said disclosure, but you probably don't have to sit there and write out what all of those three things are. So, I do want to remind you, right? Again, this is, we ran into this a few times earlier in the process related to things like scope of representation and whatnot, where the practice questions would try and tell you that the contract defines the lawyer's ethical obligations. And this is another situation where what's happening is the ethical obligations authorize the creation of a contract to allow for certain actions that would otherwise violate the rules. Okay. So again, if you are starting from the rules and proceeding to an agreement, you're good. If you're starting with an agreement and suggesting that it defines the scope and obligations of the rules, that's the wrong direction. Okay. Okay. I'm going to skip talking about implied authorization, mostly because it's a lot narrower than I think folks want to think it is. Maybe not you guys specifically, but people in general. We tend to think that folks are, engaged in that there is implicit authority for a lot more than there actually is. Okay. So, moving on. The Belge case. Here's what I will say about the Belge case. I hope you are never in this situation in practice. But it is a thing that happens. However rarely it happens, it happens too often. But it does happen. And now we have more or less coalesced as a profession around the notion that the way that Armani and Belge handled the situation is the way that we want lawyers to handle the situation. They protected their clients' confidences. They, attempted to further the important public policy interests that would have been supported by disclosure in a way that was consistent with their obligations to the client, but they always put the client first. The one thing that I sort of want to flag for you with the Armani and Belge case is this last bit at the end of the discussion in the book, where Garrow has escaped from custody. And there's some evidence that he might be stalking the attorney's kids or the attorneys themselves. There's no good answer here. And sometimes that's where we are as a profession, right? Sometimes we are faced with the decision to either risk our livelihood or risk our loved ones. The rules will tell you, and if you ask the bar council, they will tell you that the rules will tell you that you have to put your client's confidences and your client and protecting your client's interests above even the lives of your children. I will tell you, and if bar council are any good, they will also tell you that nobody expects you to wreck your life on the shoals of your client's needs, and that even if you face discipline over being in this kind of a situation, that you have to do what is right for you and what is best for you and what your values force you to uphold. And I don't know, man. I gotta tell you, I can't imagine being in a situation where I would just sort of like leave my family hanging out to dry in this situation. So if that's you, okay, but it ain't me. So I'm not going to demand that anyone sort of put themselves in a spotlight over this. But if you have thoughts on how you would handle this situation, on the things that matter to you, on the things that would play a role in your decision making, I'm open. This space is open for you. I saw that. I saw what you tried to do there. You tried to put her on the spot. I want you to do it.
All the way back here.
All right. So let's maybe talk about a situation that isn't quite so fraught. So as a reward, Mr. Thompson, tell us a little bit about what's the ethical issue in Spalding versus Zimmerman? Why is this case in a professional responsibility casebook?
Because the defense attorneys did exactly what they were supposed to do. And what they did was pretty crummy thing ethically, just as part of society, by not telling the opposing counsel, who was the plaintiff's attorney, that their client had a life-threatening, aneurysm sitting in his heart. But they were under no duty to do that. And so they did the right thing by not disclosing that.
How did the defendant's lawyers know that the plaintiff had a life-threatening aneurysm?
They hired a doctor to look at the plaintiff, and that's when they found it and kept it in their records. And then the plaintiff's attorney hired a doctor. He didn't find it. And then they knew nothing about it until I think a couple of years later, he tried to join the Army, and the Army doctor found it. So they went back to relitigate by saying, hey, you didn't tell us about this, but they were under no obligation to disclose that. The judge even chastised the plaintiff's attorney, said, hey, you should have gone through discovery and you'd have found this.
So one of the things to keep in mind, so I think that Mr. Thompson has adequately briefed the case for us, so you're off the hook. Adequately is the highest standard that I'm going to provide. It's, did you meet the floor of responsibility, and then there's all this space above it where everybody's undifferentiated. So adequately is exactly where you want to be. I want to be clear about this, that this case predates the model rules. Okay, so the duty for disclosure differs in some respects. The canons of professional responsibility imposed a slightly different set of duties. But let's transport the case forward to the modern day. And do we think that there is there's a provision in the model rule, in Rule 1.6, that would permit the disclosure of the defense doctor's report, even if the plaintiffs don't ask for it? So, whether they can get it if they ask for it, that's a question for a class on discovery, which this is not, thank God. But even if it's not asked for, would the defense lawyers have an obligation to hand it over under Rule 1.6? Or rather, would they be permitted to hand it over under Rule 1.6? Mr. Plesby, what do you think?
I mean, under Rule 1.16B1, to prevent reasonably certain death or substantial bodily harm. I mean, aortic aneurysm, that's almost as dangerous as it gets for just a lurking condition. So I think it would have been fine.
Anybody want to disagree or offer a different perspective? You're all going to let Jacob Reiser fall on his own? I think you're probably right. I think that 1.6B1 probably gives us space to allow us to move forward with this. In that, as Mr. Plesby points out, the rule allows for disclosure to prevent death or serious bodily harm. Now, you may find some, you may find some, you may find some authorities, sorry. You may find some authorities that will tell you that 1.6B1 really only focuses on disclosing crimes that your client is about to commit. Right? But that's really the purpose of 1.6B1. It might be the case that that's generally that states sort of think in those terms. That's not what the rule says. And so I think that Mr. Gillespie has correctly grasped sort of the thrust of the rule, with the caveat that there may be state Supreme Courts that disagree, that take a narrower view of the rule. So with that in mind, let's talk about that a little bit. So. As soon as the projector gets itself warmed up. So here we have 1.6B1. We have the model rule, and then we have the state-specific rule that will govern the jurisdictions where most of you will be taking the bar, or at least most Washburn students. I shouldn't say that this is in any way a representative sample. I don't know that. So I think Mr. Gillespie's right in terms of how he reads the model rule. But do we think that under these state-specific rules, that any of these states would permit the disclosure of the defense doctor's reports? Ms. Burrell, are you going to take the bar in any of these states? No? Okay, you're off the hook. All right. All right. So, do you think in Kansas the disclosure is permitted?
I think it would be permitted in Erie and Nebraska, I'm not sure, but.
Okay.
You could say reasonable or death, to prevent death, we could do that.
So, what is it about the Kansas rule that makes you say no?
And committing a crime.
Right. Exactly right. Okay. So, Ms. Wackerly, do you agree that the Missouri rule would allow for this, for the disclosure?
I think so.
Why?
The part that trips me up is where they say it relating to the representation of the client and.
Oh, there's no doubt that the doctor's report is information relating to the representation of a client. Okay, so we're definitely within, like, we're within the rule 1.6 ban. The question is, does the exception as it's written in Missouri permit the disclosure? Okay, why?
Because that there's substantial bodily harm and that is an aneurysm, right?
Okay, yeah.
That would be considered substantial bodily harm.
But is it reasonably certain to occur? like, does having an aneurysm, does it necessarily follow from that you're going to stroke out and die, or, you know, be substantially brain damaged, or whatever the consequences of those sorts of health problems might be?
No.
We feel comfortable describing that as reasonably certain? Ms. Wackerly first, and then Mr. Thompson.
From what I've ever heard of an aneurysm, sounds pretty serious enough where it should be disclosed under that.
I mean, certainly at least seems like a question of fact, right? So, Mr. Thompson, was that where
That's
you?
what I would say back to that, Molly, is that, you know, that's something that I think you can determine if it's reasonably certain by employing an expert.
Boy, just like it's a nesting doll of experts all the way down. Yes, Mr. Ron.
I also think following Jacob's, audible explanation also says. Death or substantial early harm. If that's right. Probably here.
Could you make an argument that reasonably certain only modifies death?
Probably good.
Maybe, right? Yeah, this is one of those things where the text is such that, like, you can probably reach. There's probably a lot of outcomes that fall within the zone of reasonable readings of the text. So, Mr. Odo, do you think that the disclosure would be permitted in Nebraska? Mr. Odo? Sorry. Do you think the disclosure would be permitted in Nebraska?
So, because the abortive body if it's reasonably certain.
Yeah, I think you've captured it, right? That these three, the model rule, the Missouri rule, the Nebraska rule, they're broader than the Kansas rule, and they don't necessarily have to be read as requiring the harm to be connected to the client's misconduct. Okay. And in fact, the Missouri rule doesn't mention that it has to be connected to the client at all, right? Just the information that we learn. But I think you're right. I think you guys are right that Kansas rule is narrower. I think that's a really important distinction for you guys to recognize, since an awful lot of you will be practicing in Kansas. So, okay. Questions? Okay. All right. So now we are done with you. Not with you. With you. So I want to draw your attention to problem 4-5 on page 281 and 282. So we have here a client who don't quite seem all there, right? And they're telling you that they've taken this industrial rat poison and they've accidentally placed it in a bunch of homes. And this is really salient because they're charged with manslaughter because a child died from eating this. And so you're trying to convince the client to like go and figure out which houses got the poison bomb, go in and remove it from those houses. And the client keeps going, yeah, I'm gonna do it. And you're trying to get him to let you turn over this information so that the police can take care of this. He keeps going, no, I'm gonna do it. One of the things that concerns you is that, in fact, what he might do is destroy his files that record where he was and where he left the poison. So let's start with this. Is this information relating to the representation? Ms. Olive, is this information relating to the representation?
I believe it is,
Why?
because you're representing him on the rat poison he's put in homes, and this information is where which homes the rat poison's in.
Yeah. Right. Okay. So has the client consented to disclosure? No. Okay. So we didn't escape Rule 1.6a. So here we are with 1.6b. So let's start with 1.6b1. Again, we're going to be talking about the model rules. So set aside everything that we talked about with the Kansas rules or the Missouri rules. Okay. So 1.6b1, does it permit disclosure of the information? Yes, Ms. Olive.
I want to say yes, because this is a very reasonable bodily harm or certain death if the death has occurred.
I mean, but how do we know?
That it's reasonable to assume someone would die? Or what?
I mean, so we're talking, I understand that, like, in the specific case of the house where the child did eat the rat poison, that, like, there was, someone did in fact die. But how do we know that there's any other house where something similar to that exists?
Between 30 and 40 homes, you would think at least one of them has a child. Or maybe someone not too smart, not too bright.
Right, my house.
And not just that, this is, what was it, like factory grade poison, like they're not supposed to be used in homes for the reason that they're not safe.
How certain are we?
I don't have any certainty.
If you don't have any certainty, then does 1.6b1 even apply?
But then it's not reasonable to make that certainty?
Is it?
I want to say yes.
Okay. Becker?
I mean, I could argue that the reasonably certain only applies to death, and so it's to prevent substantial bodily harm without the requirement that I need
Yeah.
to be reasonably certain.
Okay, I'm going to take that away from you. No, that's a sound argument, right? And I know that because I made it. But in the event that in fact your state Supreme Court says, no, actually, Sienter applies across the board. You don't, we're not going to apply a lower level of scienter to preventing bodily harm than we are to death, then what now? So what do you do after that, Thompson?
Well, there's a criminal law in the state that I think has a lower standard that it just requires a substantial risk of death or physical injury. So I would think that you are required, even if, 1.6B1, I believe you may or may not be able to, you still got to look at the state law as to whether you have to report.
Well, that's assuming that there's a reporting obligation here. That's a 1.6B6, right? So we're not there yet. So 1.6B1. Yes or no? Ms. Olive says yes. Mr. Becker, you're shaking your head. Did taking away your textual sophistry change your mind?
Yeah.
Fair enough, right? I think that you've correctly captured, right, that the crux of the issue is, how do you know that this will happen? And the answer is, until Harry lets you in his files, you don't, because you don't know what's going on with you. Like, for all you know, these are all, these are 30 to 40 dink houses, double income, no kids. So, there's nobody in the house who is, inexperienced enough or, impaired enough to eat rat poison. And so nobody's going to get hurt. But does that mean that not disclosing is the right thing to do? We're going to get to that. So 1.6B2, 1.6B3. Is that authorized disclosure? Yes, Ms. Hart.
I have a question. So the fact that like someone already got hurt and died, obviously, can you not weigh that into like your analysis at all?
Are you taking evidence?
Yes, but
Ask Judge Martin.
okay. They don't ask me any questions.
I was not asking a question to set you up to start like grilling you about the rules of evidence. Is to say that's a question about like how we make inferences in the law about using past instances to predict the future, and so that's a question for evidence,
Okay.
and so it's a question for Judge Martin. Yeah.
Okay.
So 1.6B2 and 1.6B3, yes or no? Authorizing the disclosure. Mr. Van Diest, yes or no?
I don't think so, no, because both qualify financial interest or property.
Yeah. Isn't it weird that we have more exceptions for disclosure related to losing someone money than we do over dead kids? Like, doesn't that suggest something is wildly out of whack about our professional priorities? Mr. Thompson.
Pets are property.
True. And a lawsuit that would require,
I choose not to agree with that because of my kids. I'm sorry, Ms. Lucy, go ahead.
That's all right. Isn't there a financial interest in my clients possibly getting sued for endangerment? Don't I have a responsibility to protect their interest that way?
So, what is it about the harm that 1.6B2 and 1.6B3 focus on that suggests that maybe that thinking isn't complete?
It's address the harm to others, not your client.
Right. So it's if the client is going to harm the financial interests of another. And so the client getting sued doesn't trigger the harm to a financial interest that would authorize disclosure. Does that make sense, Ms.
Yeah.
Gleason? Okay.
I can see it.
All right. 1.6B4, 1.6B5, do these authorize disclosure? Not on these facts, right? There may be other things going on that bring those into play, but on the facts that we have, these don't come into play. They're addressing situations that aren't relevant to us. So we're gonna pick up on Thursday talking about this problem with 1.6B6, because that's a really important, because Mr. Thompson raised a really important issue there. And then we'll carry on from there, okay? See you guys on Thursday. Take care. Turn in your character and fitness, because I don't want to give any zeros. I don't want to give any zeros. But if I have to, I will, but I don't want to. All right. See you guys later. One second.
You can-